One knife, two knife, red knife, dead wife. This stanza no doubt mimics the legendary poem from Dr. Seuss's One fish, two fish, red fish, blue fish. But the creepiness of this imitation led to an interesting legal situation involving a cartoon cat and a notorious Hall of Fame football player.
I told him, OJ, you're breaking the laws of God. One day, everybody's going to know everything that you've done, man.
In 1994, the world stopped and watched as one of the most famous football players in history was accused of murdering his wife and another person in cold blood. An infamous Ford Bronco chase and subsequent arrest later would lead to the trial of the century. The O.J. Simpson trial was a landmark legal case in the United States. They are still making documentaries and television shows about the trial itself because it was such a spectacle. The trial centered around the murders of Nicole Brown Simpson, O.J. Simpson's ex-wife, and Ronald Goldman. O.J. Simpson was accused of the double homicide, leading to a highly publicized trial that captivated the nation. The prosecution argued that Simpson committed the murders in a fit of jealousy and rage, while the defense, led by a formidable legal team nicknamed the Dream Team by the press, raised doubts about the evidence and the police investigation. I'm not going to get into all the details of the case because this story is not about that, but the trial was insanity, marked by the first real introduction of DNA evidence to the mainstream, a legendary glove demonstration, and issues of race relations that added layers and layers of complexity. In a shocking verdict, O.J. Simpson was acquitted of all charges on October 3, 1995. The question of whether O.J. Simpson was responsible for the murders continues to be a subject of debate. The legal system based on the principle of innocent until proven guilty holds that Simpson is not guilty of the criminal charges. However, public opinion remains divided, and some individuals believe he was involved in the crimes despite the legal outcome. But in 1995, the same year the Los Angeles jury entered a not guilty verdict in favor of O.J. Simpson, author Alan Katz and illustrator Chris Rinn created a parody book with a title riffing on a 1957 classic by Theodore Geisel to satirize aspects of the infamous murder trial. The parody was titled The Cat Not in the Hat by Dr. Juice. Theodore Geisel, under the pseudonym of Dr. Seuss, created the Cat in the Hat children's book series. Seuss aimed to enhance elementary school literacy by using rhyme lines and simple words for children to learn. Geisel gave varying accounts of how he created his most famous book, The Cat in the Hat. But in the version he told most often, he was so frustrated with the word list from which he could choose words to write his story that he decided to scan the list and create a story based on the first two rhyming words he found. The words he found were cat and hat. The book was met with immediate critical and commercial success, and is one of the most influential children's books of all time. The book is mainly remembered by its main character, the mischievous cat that wears a tall red and white striped hat and bow tie, and carries around an umbrella. In 1995, after the O.J. trial, Katz and Rinn, the creators, wrote Cat Not in the Hat, a parody where the facts of the O.J. Simpson murder trial were retold in the style of a Dr. Seuss book. For example, one stanza reads, "A man this famous never hires lawyers like Jacoby Myers. When you're accused of a killing scheme, you need to build a real dream team." The book's illustrations included an O.J. Simpson cartoon depicted in the distinctive hat worn by the original Cat in the Hat. Instead of wearing a bow tie, however, he is wearing a long tie, and instead of carrying an innocent umbrella, he is holding a pair of blood-dripping gloves, a reference to the gloves found at the scene of the murders. The word "not" on the cover is all capital letters and bolded, signaling its distinction from the original work. The author also chose a pseudonym that rhymes with Seuss, saying that the book is by Dr. Juice, mocking O.J. Simpson's nickname, The Juice. Those seem like simple details, but they are important to the story. Penguin Books USA Inc. and Dove Audio Inc., publishers of the work, were not licensed or authorized to use the work from Dr. Seuss and did not request permission. Dr. Seuss himself had passed away in 1991, but Dr. Seuss Enterprises filed a lawsuit for copyright and trademark infringement against Penguin and Dove, seeking an injunction before the book was allowed to be sold to the masses. In the complaint, Seuss's team alleged misappropriated substantial protected elements of its copyrighted works, and violations of the Copyright Code and federal trademark law. The authors claimed that the book was a parody, and that it was transformative content which falls under the fair use exception given by federal law. A lot of YouTubers know what that is. But this would allow the authors to publish their book because they are transforming the content enough to show that they are not just stealing the IP of the iconic Dr. Seuss, but they're actually creating their own thing. So, to start, acceptable transformative uses include, but are not limited to, critical reviews, political commentaries, or parody. Critical reviews can use passages from the original work, as it gives a critical evaluation of the work or the creator, thus creating an intellectual exchange. Political commentaries enhance freedom of speech, as people don't need to worry about being sued for copyright infringement while commenting on politicians. And the parody exception is there because parody can be a powerful tool for cultural commentary, allowing individuals to comment on and engage with popular culture. But the parody must be shown to be a mockery of the exact work they are referencing. These examples of all the transformative uses have one thing in common. They express their own opinions on the original work or the original creator. Yet the argument from the court deciding the case between Dr. Seuss and Penguin Publishing found that the cat not in the hat used Dr. Seuss's style, which is famous for its rhymed and easy to understand lines, but they ridiculed O.J. Simpson and not Dr. Seuss. Like even the name Dr. Juice, even though it rhymes with Seuss, it is mocking O.J. Simpson and not Dr. Seuss or his characters. So the court found that a quote-unquote parody book is mainly mimicking Dr. Seuss's style to ridicule someone who is not Dr. Seuss. This is not considered parody, this is satire, which is not transformative content. But another important factor the court considered here is whether it harmed Dr. Seuss's potential market. Dr. Seuss's books have sold more than 700 million copies globally, and it's been translated into 20 different languages. The goodwill and reputation associated with Dr. Seuss's work is substantial. Although I doubt that the parody book would have a big impact on Dr. Seuss's market, it could have given the potential readers an illusion that the two books are similar, and that Dr. Seuss had authorized the creators of the parody to do so. The final decision from the district court, and later on appeal, granted Dr. Seuss a preliminary injunction saying that the Penguin Publishing was not allowed to sell these books. A lot of legal experts have actually sided with Dr. Juice and argued that the court was wrong in finding the book not to be a parody. One of the main arguments is the inferred market harm if the cat not in the hat was allowed to be published, because the actual book was never allowed to be sold. Attorney Stephen Carlisle contended, saying, "Would you really give a 6-year-old the cat not in the hat instead of the cat in the hat? I seriously doubt it." Carlisle also argued, mentioning in an article, that another court later found that Oh the Places You'll Boldly Go, a parody book of Star Trek using similar wording and illustrations as another Dr. Seuss book, All the Places You Will Go, was enough to be transformative. So the copying of the distinctive hat of the cat in the hat and the back cover is sufficient to support a finding of copyright infringement. But the slavish copying of the entire book of Dr. Seuss is not infringing? In my opinion, I don't see the differences between the two books. But I think it is because one book was about Star Trek and the other was about a double murder. The Ninth Circuit continuously mentioned that their decision had nothing to do with their feelings on the content. As Justice Holmes, the sitting judge on the cat not in the hat appeal, explained, "Our analysis does not take into the account whether the cat not in the hat is in good or bad taste. It'd be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of a work. If it didn't matter if the book itself was in bad taste about the most famous court case of modern history, then why would you even bring that up? The Star Trek parody is clearly good-natured as compared to mocking someone who is accused of a double murder. But when the legal system starts bending the law for what they feel, rather than what is right, we are going to have real problems, if we don't already." It is important to recognize the difference between legal principles and personal judgments. You can find the cat not in the hat reading on YouTube, but for the most part, it was just a blip in the pop culture world during a wild time. But the legal case that sprung up because of it opened up a dynamic that makes us question the fair in fair use. Ultimately, the Dr. Seuss and O.J. Simpson parody case underscores the evolving nature of intellectual property law in response to artistic expression. Not bad for such a ridiculous book.